afternoon, everybody, and welcome to our Zaremski talk today. I'd like to thank our alum, Miles Zaremski, and his wife, Elena, for endowing this series of noontime lectures, and we're very grateful for that. And there will be CLE credit for those who are watching online, which we will tell you the information about at the end. We're very lucky to have our speaker today is Professor Jessie Hill, the Judge Ben C. Green Professor of Law here at Case Western Reserve University, and also the Director of our Reproductive Rights Law Initiative. And she is going to be talking on reproductive rights and review, law and policy developments in the Trump administration so far. So without more, please welcome Professor Hill.
Thank you. Very nice to be here, and yes, thank you for hosting, and thank you to the Zaremskis for this as well. So basically, I'm gonna I wanted to give a bit of an overview of what, as the title suggests, what's been happening on the reproductive rights front, both in Ohio and nationally, like what have been some specific, policy developments, as well as just some sort of, I'll wrap up with some general trends that I have been observing as well, and where things might be going. So first, we're going to start with Ohio, our own little corner of the world. So in Ohio, we passed an amendment to our Constitution via ballot initiative in 2023 that enshrined a right to reproductive freedom in our state constitution. Since then, there really has not been very much legislative action on reproductive rights, one way or the other. Before that, we had seen a lot of laws being passed on a regular basis restricting abortion rights. Like I said, here, since then, there hasn't been very much. There was something in 2025 that was really kind of marginal, related to reporting of abortions to the state and funding. There's always an increase of funding to so-called crisis pregnancy centers, which are centers that are designed to dissuade people from choosing an abortion. But other than that, no concrete restrictions. There have been some sort of what I call proactive legislation introduced, like attempts to support abortion rights or expand reproductive rights. Those have gone nowhere, expected to go nowhere, because they are supported by the minority, who are the Democrats in our state legislature. However, the current legislative session, there have been a number of bills proposed, and you probably can't read that. They're not, I'm not going to go over them in any depth, but there have been a bunch of new restrictions proposed on abortion. It's kind of interesting to see. I mostly just want to mention, we don't know whether they're going anywhere, whether they're going to pass or not pass. Ultimately, if they do, they will probably face a legal challenge, but it's just been interesting to see that kind of after a 2-year hiatus, it's like the Ohio legislature has decided to wake up again and start trying to regulate abortion in the state. I'm going to skip that slide, but so the other thing that's going on in Ohio is that there's been litigation. So since that constitutional amendment passed, there have been a number of challenges to existing state laws that restrict abortion. And so again, I'm going to just touch on those fairly briefly. But the big one has been the 6-week abortion ban that was in effect for a period of time after the Dobbs decision came down in 2022, and the U.S. Supreme Court held that there was no constitutional right to an abortion. Ohio already had this ban on the books. It was just not being enforced. And so pretty much as soon as that decision came down in 2022, that ban went into effect. And then since a couple months after that, there was litigation commenced to block it. It was blocked, and then our constitutional amendment happened. And so that, interestingly, that litigation is still ongoing. So the most recent thing is that The state actually agrees that the ban itself is not constitutional and cannot be enforced. So Ohio can't ban abortion now that we have this in our Constitution. However, there are some sort of like ancillary related provisions that are in the law that are designed really to support the 6-week ban that the state is still arguing over. It's basically trying to preserve whatever it possibly can of these restrictions. Again, I'm not going to go into any detail about them, but there was an argument in the Court of Appeals on September 16th, and that appeal is pending right now. We'll see what the court decides. Other than the 6-week ban, there is a law in Ohio that requires the tissue after an abortion be cremated or buried. That law is currently blocked, but the litigation is ongoing and it's on appeal right now. So you can't dispose of it by the usual medical means. You have to go to a funeral home. Restrictions on mifepristone, which is the medication that is used for providing a medical abortion as opposed to a procedural or surgical abortion. Ohio had various restrictions that go beyond what like the FDA requires, and also had restrictions that prevented nurse practitioners, so-called advanced practice providers who are not physicians from prescribing the medication. Those restrictions have now been blocked, and that litigation is ongoing. One of the biggest, I think, pieces of litigation post constitutional amendment is around the 24-hour waiting period. Ohio used to require a 24-hour delay between going in person to the clinic to give consent to your abortion procedure, or the hospital or wherever, and then you have to wait 24 hours and then you can have the procedure. That was really, really an onerous thing for patients, having to make 2 trips for no medical reason at all, for people who had to take time off work, arrange childcare, maybe travel from a distance, especially right now in our post-Dobbs environment where a lot of people are traveling to access care. This was an incredibly burdensome requirement. That is currently blocked as well. All of these, by the way, these cases, the litigation is still ongoing. So ultimately, the ultimate arbiter will be the Ohio Supreme Court. That is going to weigh in on that, and we'll see whether they end up staying blocked or going back into effect. Finally, there's something called a written transfer agreement that's required for clinics to operate. The short version is it's basically a medically unnecessary requirement that clinics need to stay in business. They have to get a hospital to give them one of these agreements, and that requirement is also being challenged, and litigation is ongoing. That's the picture in Ohio in brief. Like I said, I want to touch on what's been going on at the national level as well as some overall trends, and then I do want to leave time for Q&A as well. So. Okay, I think this is an area that feels like it hasn't gotten very much attention from the Trump administration or at the federal level. However, there really have been a number of things that have been going on at the national level. I don't know why it's not. Oh, here it goes. Is it going to advance? Let's see. There we go. Okay, so and I'll touch on each of them kind of briefly here. There we go. I don't know, for some reason the slide is not advancing the way it usually does. Okay. So I'll touch on each of these measures that has been sort of on the federal level as soon as I can get past this slide here. There we go. Okay. I think one of the biggest and most significant things that has happened has been the defunding of Planned Parenthood at the federal level. So, gosh, I don't know. This keeps being kind of sticky. I don't know what's going on. Let me see. Oh, there we go. Okay, so it's the defunding of Planned Parenthood. So there was a Supreme Court case that basically gave the green light to states, made it easier for them to kick Planned Parenthood out of their Medicaid programs. And what we're talking about here, I want to be clear, because if you just kind of hear about it casually through the news, it may not be apparent, but the Medicaid funds, at least at the federal level, generally do not pay for abortions. They do pay for a lot of other, or they did pay for a lot of other services that Planned Parenthood provides, such as contraception, sexually transmitted infection treatment and testing, preventive services, like pap smears and mammograms and things like that. So and some states use their own Medicaid funds to pay for abortions as well, but the states that have tried to kick Planned Parenthood out of their programs were not states that paid for abortions. So like when we say that South Carolina, for example, kicked Planned Parenthood out of its Medicaid program, that means for non-abortion services. So Planned Parenthood can't get funds for all these other preventive care services, for example. So that happened in the summer, and then not long after that, the federal government went ahead and passed the so-called One Big Beautiful Bill, which took funds, or which basically at the federal level said no federal money can go to Planned Parenthood. So it has resulted in an almost total defunding of of Planned Parenthood. Ironically, actually, the only thing they are getting money for now is abortions in states where the state allows them to get that money. So this has had, like I said, I think this has been the federal measure that has had the most significant impact in the reproductive rights and health realm. Planned Parenthood has brought lawsuits to try to block this provision in the bill, but they had some initial success and then haven't so far. So some states are passing programs, creating programs to help try to fill the gap in care, but really a large number of people, particularly people with lower incomes, depend on Planned Parenthood for these services. Ohio is actually one of the hardest hit states by this measure because a combination of the fact of having expanded our Medicaid coverage, how many people in Ohio are on Medicaid, how many of them rely on Planned Parenthood for preventive health care services, and we've had a number of clinics, again, that don't provide abortions, but that have closed as a result of this. What else has been going on? Well, a federal judge has blocked the reproductive health privacy rule that was passed under the Biden administration that was designed to protect the reproductive health information of patients who travel from a state where abortion is banned to a state where it is legal to access that care. It basically says you can't access their information for law enforcement purposes if anyone wanted to prosecute the patient or the doctor for that care. That has been blocked, and honestly, the Trump administration is not enforcing it at this point anyway. Similarly, the Trump administration rescinded guidance that was passed under the Biden era, interpreting a federal law called EMTALA that it's a general law that requires hospitals to provide emergency stabilizing care to patients who show up in their emergency rooms, regardless of the patient's ability to pay. The Biden administration had passed guidance, had put out guidance saying, after Dobbs, saying if that stabilizing care is an abortion, then we just want to be clear that where it's necessary, you have to provide it regardless of state law, because federal law preempts state law. And they said, we're just interpreting what EMTALA says, which is a general mandate to provide stabilizing care. The Trump administration rescinded that and then didn't replace it with anything. So it's left a lot of confusion about what is the status now of that rule. There is litigation ongoing under EMTALA to try to clarify. There's something called the Pregnant Workers Fairness Act, which requires employers to accommodate workers for pregnancy-related conditions. The Biden administration put out guidance saying that includes, for example, if an employee has to leave the state or just has to go miss work to access an abortion, there's a federal judge there have been a couple of cases actually where that provision has been blocked as well. Oh, sorry, that's not very easy to read, but also one of the big issues under this administration has been Title X. So Title X is another federal funding program that provides funds for family planning services. So, specifically contraception, largely, and provides low cost or no cost services to people who can't afford to access those services. And in the private market. And so it's again, a massive program. Planned Parenthood has been a big recipient of those funds. And there has been a lot of sort of political ping-ponging back and forth over what rules apply there, because again, the program does not fund abortion, but there has been a back and forth over whether within that program, if you are seeking contraception or maybe you're getting a pregnancy test and you find out you're pregnant, can the provider counsel you and refer you to an abortion provider? The Trump administration has tried to put out rules that say you cannot. And so that has been an ongoing issue. However, the bigger issue now, I think, is that the Trump administration has basically just pulled back Title X funding from numerous Planned Parenthood clinics, really with no legal basis for doing that at all, and has proposed, I think, to eliminate Title X funding altogether. So it's really very much up in the air. I think the freeze on the funding has had an even bigger impact than the, the rules around referral for abortions. This is just a little to give you a sense of how significant this is, and how significant Planned Parenthood's role in particular is in providing these services. Is that, if Planned Parenthood is completely out of the Title X program, other sites would need to increase their client cases by an average of 70% to make up for the gap. That's how much they sort of dominate that field. Another thing, this was like a very early on move by the Trump administration, was to limit FACE prosecutions. FACE stands for the Freedom of Access to Clinic Entrances Act, and that's a federal law that prohibits, and it makes it a crime as well as a civil cause of action, if people block, obstruct access to healthcare clinics, to reproductive healthcare clinics. So basically, not just protesting, but actually, protesting in such a way that prevents people from accessing the clinic. The Trump administration said they are not going to pursue any cases under that law unless they are extreme, meaning that they result in serious physical injury to someone or death. They dismissed right off the bat in January or February 5 pending cases that the prior administration had brought, including one here in Northeast Ohio. Again, something called the global gag rule. This is something that is another kind of like Title X. It's like a political ping pong. It depends on which administration you are in, whether they enforce it or not. Sometimes it's called the Mexico City policy. What it says is that federal funds that go abroad to aid groups internationally, if those aid groups take those funds, they cannot, either with those funds or with their own funds, they cannot not only provide abortions, but they can't advocate for abortion rights, advocate for changes in the country's abortion laws, refer for abortion, have any connection, basically. Again, this is something that numerous Republican administrations have put in place. Democratic administrations generally lift it when they're in charge. Right now, it's become a little bit irrelevant because we've pulled back on almost all of our federal foreign aid anyway. So it's that again has been the bigger action, or more significant action on this front. And then the Veterans Administration also instituted a policy change under the Trump administration to saying that it will only cover life-saving abortions at VA facilities. It will not provide them in other circumstances where they were covered, which included basically medical reasons falling short of life-saving. Okay, the other thing on the reproductive rights and health access front that to be aware of is that the Trump administration made a lot of hay. Well, actually, Trump as a candidate made a big point that he was going to be, right, the IVF president. He was going to be the fertilization president. He was going to make IVF, in vitro fertilization, right, available to everyone free of cost. This was his promise for people who were struggling with fertility and trying to have kids. So it's a little timeline of how it's played out. Basically, Trump issued an executive order in February of his his first year, ordering various agencies to look into possibilities for making IVF accessible and affordable. And then they were supposed to produce a report within 90 days, which was May of this year. There has been no report still. Rumor has it that there is a report. It just isn't quite ready to release yet. In the meantime, the only other thing that has happened since February on this front is he made an announcement, Trump made an announcement like a couple weeks ago, basically saying that he had negotiated a lower price on fertility drugs, which you can access through the soon-to-be created Trump RX, prescription drug website. But even if that's the case, and I mean, it may well be the case. Negotiating lower prices on drugs, that's great. That could help people for sure. It's not the most expensive part of the procedure. It is not going to make the procedure, which costs about $20,000 to $30,000 on average per cycle, suddenly affordable. Even if it's true, it's a pretty small move toward accessibility and affordability. The other thing that has been going on this IVF front, and might be part of the reason why this report is delayed, is that this concept of restorative reproductive medicine has kind of taken over in the IVF world. This is kind of an idea that has been promoted by certain conservative groups, religious groups. The idea is basically that you should treat infertility by treating underlying medical conditions that might be causing it, like endometriosis or something, or just other illnesses, and not use IVF. Now, if you talk to fertility doctors about this, they'll say, yeah, that is just IVF minus the IVF. So it's just fertility care minus the IVF, because they already do that. They already think that's part of the work. So it's basically just trying to take IVF out of the equation. However, it's, again, rumor has it that it's featured prominently in a lot of conversations in the White House. It's opposed by mainstream medical groups because of what I just said. It's obviously linked to sort of the idea that embryos, including frozen embryos that are to be used in fertility processes, are persons, and therefore that they shouldn't be destroyed to create life. It's started to get some traction in some states. So there's an Arkansas law, for example, that requires insurance companies to cover RRM. It's also been incorporated into the Title X program. So while they have been cutting back on funds to Planned Parenthood, they are creating grants for clinics to engage in this kind of fertility care. Federal legislation has also been introduced that would fund research in this area and education. There is other legislation, again, independent of the Trump administration, but that has been proposed by members of Congress to fund IVF for military families. So far, it hasn't passed. It was proposed once before and just never got a vote. So, that may or may not still happen, I think. It's a freestanding bill. The one thing we haven't seen is, and so I'm calling it the dog that didn't bark yet, because it still may bark, but is something called the Comstock Act. So I think I've given this kind of talk for a few years now, and the past couple years since Dobbs, I've always said, the big fear is the Comstock Act once we have a federal administration that is anti-abortion. Because the Comstock Act is a federal law, not a state law, but a federal law, so it applies throughout the country. It's from 1873, and what it says is it basically makes it illegal to send obscene materials through the mail, and then defines obscene materials as anything that can be used for contraception or abortion. However, the contraception provision was repealed in the 1970s, but not the abortion provision. It hasn't been enforced for decades because we had Roe v. Wade in place, and that was the law of the land, and so it was understood that you couldn't enforce this while there was a constitutional right to abortion. It was not enforced in the Biden administration because, again, it's at the federal level and the Department of Justice that enforcement would occur. As soon as Trump was elected, there was a lot of thought that this might be the tool that they pick up that's just kind of lying there, right, to use, and that they might start enforcing this provision, which would probably forbid, at the very minimum, mailing of abortion pills, which is how they get not only to individuals, but also to clinics, right, from distributors and manufacturers and so on. It could just, like interpreted literally, it could be a nationwide abortion ban because you couldn't mail anything that could be used for an abortion. So it hasn't been enforced yet. There has not been really any direct threat to do that at the federal level. We'll see what happens. I will say the actions that have been happening with respect to the medication, the abortion medication called mifepristone, again, nothing directly on Comstock. However, and I will note that the Trump administration in litigation has continued the Biden administration's defense of the FDA's approval of mifepristone. That's you want to not read too much into that. It's most of this litigation has been challenging mifepristone's approval and the conditions of its approval and trying to put more restrictions on the medication. The fact that the Trump administration has been continuing the defense, they could take more radical moves, but they're kind of in the middle of litigation. It's been a lot of procedural stuff, so it's not clear that they, where they really land on this. One thing that is significant is that Department of Health and Human Services and the Food and Drug Administration has announced that they are reconsidering, they're reviewing mifepristone and considering whether it should have more restrictions. And this kind of coincides with the release of a study. Here's a picture of it. It's not really a study. It's not peer-reviewed. It's not a medical study. It's really kind of junk science, but put out by an anti-abortion group, basically. But that has this sort of veneer of scientific validity that purports to claim that despite decades of, rigorous clinical studies showing the safety of mifepristone, they claim that there is a 10% serious complication rate from using the medication. There's a whole, it could be a topic of its own. There have been several rebuttals pointing out flaws in the methodology and how they reach their conclusions, but in any case, this has been something that has been getting quite a bit of attention, and actually in the Ohio legislature as well. So it's been, legislators have been pointing to it as impetus for further restricting medication abortion in Ohio as well. We'll see what happens. Okay, so that's my like sort of summary of what's been going on at the federal level. Like I said, I just want to spend the last few minutes kind of talking about broader trends and what's coming down the pike. So, where we are today, 3 years after the Dobbs decision, there's still litigation in different states over abortion bans and trying to challenge them on different kinds of legal theories that don't rely on, like Roe v. Wade or a constitutional right, to abortion in the 14th Amendment. They've really, and it kind of pains me to say this, but I really think that they've mostly run their course, that there's not going to be a big change in the status quo from here on out, probably. So you can see, here's what the picture looks like. The darkest states are the most restrictive on abortion, and then the gray states are the least restrictive. And so this shows you kind of where abortion is restricted. I don't expect it to change very much. Also, pretty much all the states except for one or two that could put this issue on their ballot have done so already. So a lot of states, particularly those in the South and Southeast, do not have ballot initiative processes. It's not possible to put an issue before the people to vote on, like whether to have a constitutional amendment. So like I said, I mean, I think at the state level, not much is likely to change. One interesting development is that there have been some lawsuits brought claiming that abortion bans violate some people's religious freedom. So some of these have been brought, for example, by Jewish individuals who say, you know, according to my religion, I'm actually religiously required to have an abortion in certain circumstances where it's forbidden by state law. For example, if my health is at risk, but maybe my life is not immediately at risk, but my health is at risk, I'm actually, you know, my religion dictates that I should have an abortion in that situation, but I couldn't access it in the state. So there have been a few of those cases working their way up. They're actually surprisingly, so far, they've been successful in Indiana and Kentucky, places you wouldn't necessarily expect, right? However, it hasn't changed the law yet. In Indiana, it's just been a few plaintiffs, and they're kind of figuring out what the scope of the ruling is, and then does it only apply to those plaintiffs? In Kentucky, it was initially dismissed for lack of standing, and then the appeals court reversed, so the case is still ongoing. No, so none of these have actually blocked the entire state laws, but like I said, it's kind of an interesting development, and let's see where it goes. Also, you know, this was something that there was a lot of talk about right after Dobbs. Was like, what about people traveling to other states or helping people, giving them information about traveling to other states for abortion? Is that going to subject people to criminal liability? There have been a few cases, and the trend seems to be that federal courts are striking these down as violating at least freedom of speech, where what they criminalize includes like telling people, giving them instructions, giving them advice about how to get out of state. So two of these laws in Tennessee and Idaho involved laws that prohibit helping a minor travel out of state to access abortion. And then there was some early on, and the Attorney General in Alabama took the position that he was going to prosecute anyone who helped anyone, even adults, leave the state to access abortion. Again, right now that has been blocked, has been enjoined, so I think that litigation is ongoing as well. Speaking of travel, this is an extremely complicated picture. There has been a huge amount of travel across the country for abortion, to access abortion care. This is kind of a cool map from the New York Times. So the thicker the arrow, the more people like traveled in that direction. And so it kind of visualizes that. And then the red ones are from states where abortion is banned into states where it's legal, and the gray are from like one legal state to another. So as you can see, it's a very complex picture. There is a lot of travel. Some of the really, I mean, Illinois might be the absolute biggest sort of destination state across the country. New Mexico's a big one too. Because of this and other reasons, also because of the ease of accessing abortion pills through the mail, online, and through online services, I think interstate conflicts over abortion might be really the next big fight to work its way up to the Supreme Court. Not this term, maybe not next term, but these cases are working their way up. So really the basic issue and the way it presents itself is that there are these so-called shield laws where providers, physicians or nurse practitioners or whatever, are sitting in these states where abortion is protected and legal, and they also have something called a shield law that basically makes it very difficult for other states to prosecute those providers. And so providers will, over telehealth, basically prescribe medication into states like Texas where abortion is illegal. And so that's how so many people across the U.S. are still getting access to abortion pills, even in states where it's banned. However, some of these states have started to indicate their displeasure with this in very concrete ways. So a few things that have happened very recently. Texas is suing a doctor who has been providing abortion pills by mail in New York. Louisiana is actually trying to indict, or did indict, the same doctor. Texas passed a law recently that gives anyone a right to sue someone who mails abortion pills into the state. This might remind you of like the SB 8 law where you can like sue anyone for providing an abortion. Now it's just for mailing abortion pills. There's also a private lawsuit by an individual in Texas against Aid Access, which is one of these online services, for wrongful death on behalf of a woman who was, the wrongful death of the fetus, not the woman, by this woman who claims she was tricked into taking the pill after her partner ordered it online. I don't know much about the facts of this case. I can't warrant that they're true. I've heard that might not actually be the case, but I don't know. Also, a private lawsuit by a man in Texas against a California doctor for providing pills to his partner. Sorry, so let me go back. So in any case, I think all of these, are potential cases that could bubble up, will eventually come before the Supreme Court and raise the question of the scope of, one state's authority to enforce its law extraterritorially, but also the ability of the shield states to really block those states' judgments from being enforced in their states. So it's a complicated area. We can talk more about it in Q&A if you want. The final thing I just want to raise is this idea of personhood, which is kind of seen by many, particularly anti-abortion groups, as their end point, their end goal, that this was always what was really being sought. The idea of personhood, it means different things, and you hear the term bandied about a lot. Generally, it's this idea that, fetuses, embryos, fertilized eggs even, are persons under the law, entitled to, the protection that other persons have. Of course, if this were the case, it would be, you couldn't have abortion at all, right? States wouldn't even be allowed to permit abortion, because if fetuses and embryos are people, they have 14th Amendment rights, they have the right to life, they have the right to equal protection of the laws, so it would be illegal to, just legalize killing. It would be unconstitutional to legalize killing a class of people, right? So that's the idea, that it would result in banning abortion nationwide. But when you use this term, it's important to keep in mind that a fetus or an embryo or even a fertilized egg could be a person, quote unquote, for one purpose, but not another. So, we already have laws in states where a wrongful death that results in the death of a fetus is a separate cause of action, where fetuses are persons defined by the wrongful death law, maybe at a certain point in pregnancy, or if certain conditions are met, it could be for inheritance law, it could be for constitutional protections, right? So just because a fetus is a person for wrongful death law doesn't mean that the fetus is a person under the Constitution. The law can define that term differently for different purposes. I would say there's no state yet in the US where fetuses and embryos are, full-fledged legal persons under the law for all purposes. Like I said, there are groups that are working to achieve this, but I do not believe that's the case. There are places where abortion is severely restricted, some places where IVF is somewhat restricted, but no place where there has actually been a constitutional ruling holding them to be persons for all purposes. But the other context in which this kind of concept comes up is just to say, even if the law doesn't directly enshrine that and say, person shall include fetuses, embryos, etc., there are certain ways in which this this personhood trend is kind of creeping forward, and that can occur through things like criminalization of certain actions by people who, for example, there have been a number of prosecutions in Ohio and elsewhere of people who have miscarriages, and then the state determines they didn't dispose of the remains of that appropriately, and they prosecute them for abuse of a corpse, right? So kind of equating the fetus to like a corpse, a person. Things like that, right? Or attempts to confuse certain forms of contraception and actually abortion, and to say that they're equivalent. So things like that can be measures that sort of promote personhood in various ways. But like I said, we haven't really gotten there yet. The question is, are we going to get there soon? So I'm going to stop there. We're right at about 1:45, so I guess that leaves us about 15 minutes for Q&A. So thank you.
So I guess just with the Comstock Act, I was wondering how people are defining the term male, specifically in terms of like shipping to clinics. Is that through U.S. Postal Service? Is it, packages being delivered on 18-wheelers? Kind of how they're defining that specific term within it, because that seems to be questionable.
Right, that's a great question. That's a very thinking like a lawyer type question. So the statute actually says through the U.S. Postal Service or a common carrier. So like FedEx, UPS would qualify as common carriers as well. I think there might be sometimes maybe like Amazon, because they use private drivers or something, might not be. I think there are some, possible delivery mechanisms that are not common carriers, but for the most part what's used now are. So yeah, it's pretty broad.
Gotcha. Thank you.
Yeah, thank you.
Questions? See if we have any from online.
Okay, if not, there's one over here.
Oh, well, let's start there.
With the
Wait for the
Comstock,
microphone for online, please.
with the Comstock Act as well, I know you said the contraception part of it has been repealed. Is it possible for that to be added back on if it is enforced federally, or do you think that is not an option legally?
So I don't think that the Comstock Act is likely to be applied directly to contraception anytime soon, or that Congress would pass repass that provision. But one thing is that there has been kind of movement to, as I was just alluding to at the end, to kind of elide contraception and abortion and suggest they're the same thing, or that certain forms of contraception, especially ones that can act after fertilization, that those really are abortion. And so I think that would be the bigger risk, is that those forms of contraception then become interpreted to include, to be defined as abortion, or that, some enterprising prosecutor decides to interpret it that way. Yeah. Also, I'll just say, by the way, there has been a move to get a bill on the sort of proposed to repeal the Comstock Act, in its entirety, or at least the abortion parts of it, and it hasn't gone anywhere. I think one of the concerns with that is if it fails, then we could be in a worse position than right before we started, because then you lose all your arguments that Congress didn't even know this existed and didn't mean for this to still be enforced. So sorry, go ahead, Kayla.
I went to a Federalist Society event, I believe last week, where they were discussing fetal personhood, and the speaker, I don't want to misconstrue what he said, so it might not be exactly this, but he said something along the lines of his ideal way it would come about in a case is if the defendant was a father that could use it just with burdens of evidence. It'd be better as a defense case for the father. And And I've heard that, maybe not in legal spheres as much, but like I've heard a lot of conservative talking points regarding like fathers' rights to have their child. Father should have a say in abortion, so and so. And I'm just wondering, like, do you know anything or have anything to say about like the legal standing of a father in this scenario? Because I understand saying, you know, you have a right to a family, you have these fundamental rights, you have the right to build your family, create your family, but tied into that is a right you're putting onto someone else's body and someone else entirely. I can't say that I have a right to a family, so you should make a child with me. Like, I can't, that's just, that's a very strange framework for me. So I'm wondering legally if that would hold.
That's a really interesting question. I mean, and I think, you know, you're right to pick up on that because it has been a major strategy, like post Dobbs, also of these lawsuits. Like you've seen, like the private lawsuits are almost always where they're trying to sue abortion doctors or sue, you know, for wrongful death to try to establish the personhood of the fetus or embryo. Like to say they're almost always brought by the partners. There's one that was brought by a woman, right? But usually they're brought by male partners who are kind of like, my understanding is essentially recruited to bring these lawsuits. You know, the problem, it's really complicated, or it's really hard to answer, because the problem is when Roe v. Wade and Planned Parenthood v. Casey and these, you know, Supreme Court's protecting a right to abortion, Supreme Court opinions were in place, it was understood that the right to terminate a pregnancy was both about the right to choose not to be a parent and the right to bodily integrity, right? Like, just like it's, so if there was a conflict, you know, the Supreme Court, for example, struck down spousal consent requirements, partly because, you know, look, one person is going to have to win this, right? And it should be the person whose body is at stake, right? Or whose body is involved. That's the person who has a greater interest. Now with Dobbs overruling that, Dobbs didn't really say whether that right is still exists. I mean, I would like to think that there is still some freestanding right to bodily integrity as a constitutional right, like the state can't, you know, force you to undergo any kind of like medical intervention or surgery or something like that. So I would like to think that's still true after Dobbs. But, you know, Dobbs seems to say pretty clearly that bodily integrity right is not enough to justify abortion, right? So where does that leave us? I think it does. I think the answer is just very unclear now to what extent could, like, for example, could a state empower male partners to make decisions or, you know, something like that, or give them special rights, right? They do, and you know, they do under some of these bans have like rights to sue and things like that. So yeah, it hasn't been tested, but I think it is definitely a real threat because we just don't have a very clear answer. Mm-hmm.
I kind of had a similar question because I also sat in on the FedSoc and I saw you were there as well.
Yeah, I had to leave early though. I didn't catch that part of it.
I try to stay for the most part, but to build off of her question, do you know of any cases where the father is also listed as a defendant along with the physician and the mother? Because it seems, I know we've heard some cases where actions brought against the physician that's providing any abortion-related care, but I'd be curious if, kind of on the flip end, as opposed to the father bringing the action, that it's also brought against the father for impregnating a woman that, you know, so that you're saying you have not heard of any?
No, I haven't. And actually, they tend not to sue the pregnant, like, woman or person herself either, because mostly for optics, but
okay, I was just curious. And then the second part, so like a big at the end of that FedSoc lecture, I had asked, I was like, it seems like there's a little bit of contradiction here, considering that this is what I'm understanding his point to be, that the fetus is similar to like an infant or a toddler, another phase of a human life. which is why they have 14th Amendment protections and the whole quickening aspect of it. I said, how are we able to use what we know now, and that the fetus has movement and whatnot, whatever you want to. We were speaking very factually, as if things were fact, which is why I am saying things with quotations. But I said, how are we using originalism if we're saying, hey, we now have this understanding that a fetus has movement? And I did ask, and it was towards the end, but he said that that was information that was available during the ratification of the 14th Amendment, which I don't believe is true, considering that was in 1868, and I don't think we had ultrasounds to understand if there was any movement of a fetus. What do you make of... I was really trying, I was coming from a place of trying to understand this originalism concept.
So, yeah, and I do not put a lot of stock personally in originalist methodology. So, I mean, I kind of fundamentally start from a place of skepticism about that as an approach to begin with. However, to try to put it in the best terms, I think what I understand the argument to be is that those who were, around at the framing of the 14th Amendment, including those who helped to frame the 14th Amendment, thought that person, as it's used in that amendment, included fetuses, and that was partly because of this broad language that they used about protecting everyone, partly because, as it so happens, the campaign to ban abortion sort of coincided chronologically with that time period, with the adoption of the 14th Amendment. The two events, to my understanding, don't have any relationship to each other. In fact, the campaign had started a little bit before, then there was the Civil War, and it kind of stopped, and then it resumed. And it was, I mean, a lot of historians have written that this campaign to ban abortion was really sort of a move by physicians to kind of assert their jurisdiction over pregnancy, and in the movement toward professionalization, and to kick women largely out of the profession, women who were midwives, who were actually, attending births and so on, and also, assisting with abortions. The irony is that, again, historians who have looked at this say that, all of those abortion bans, and they're right that around that time, the law evolved such that every state in the country banned abortion, but they all contained an exception for the life of the woman. And the way that exception was understood in the 19th century was basically, it's up to the doctor. If you can find a doctor who will say you need this to save your life, you can have it. There was no, we didn't go before ethics boards. We didn't have insurance claims that had to be filed and medical necessity verified, whatever. So basically it was much more available then than it actually is now in a lot of states. And so, so I think that, and then the other move that's made is this sort of we learned, I think you were alluding to this, we learned that actually, scientifically, life begins at conception, which I think is, you can talk about what science did or didn't exist at the time, but I think to say that, when life begins is answerable scientifically is not, surely it's a philosophical, moral, religious question, not a scientific one, I think. So, but I think it's kind of arguing that belief came into being around the same time. So anyway, I think it relies a lot on this historical coincidence of the doctors' campaign to ban abortion happening around the same time as the 14th Amendment. No one seemed to really think they had anything to do with each other, as far as I can tell. But yeah, thanks.
Any other questions?
One more.
Okay, one more question. I also was wondering about this goes to the personhood, but also just more broadly from a legal perspective. When a pregnancy is at the point where the fetus is not viable outside of the woman's body, I struggle with how the law would categorize that as anything other than an extension of the woman, right? Mm-hmm. Whereas if you're in the third trimester and the baby could theoretically survive, I can understand, okay, this thing has rights, this is very close to being a human, but I mean, those first weeks when you have a total ban, even at 6 weeks is incredibly early. A lot of people don't know it's 6 weeks. I just don't understand what like all the way fundamentally, what is the legal basis of that?
So I think there are two, right? So again, to sort of give credence to this perspective, I think there are two approaches. One is to say, kind of like along the lines we were just talking about, like life begins at conception, and this is scientific fact, although again, I'm kind of skeptical that that's something that can be established scientifically. I think it's more of a moral or religious proposition, but that legislators adopt that view, or that they have the freedom, especially after Dobbs, to adopt that view that that is a life, and therefore, we can ban abortion to protect that separate life, which is an interest that is just as important. Where it is located, they'll say, it doesn't matter. I think the other perspective is to say we recognize it's not a separate person. But it is, it has potential to develop into a life, and therefore it has moral value that, like, beyond just beyond just like a kidney or something, or like, that is within your body, that is part of you. It's not, it has the potential to become something else, and because of that, we give it a moral weight that, maybe doesn't say it's equivalent to a walking around person, but it's something more than like any other medical procedure, and that's the other kind of route. And I think, once you say that, I think people can start to disagree about what kind of medical weight or moral weight it deserves, right? And whether or not the state should be determining that. But I think, that's the other thing that Dobbs kind of says, like, up to states to decide what weight they want to give that. So, and that's really where Dobbs is, right? Dobbs doesn't say it's a person, right? Otherwise, abortion would be banned right now nationwide. Dobbs says up to the state to decide what moral weight to give that embryo or fertilized egg.
So we're out of time, but let's thank Professor Hill again. Do we have something for CLE? Do we have to tell people?
Yeah. For those who are doing CLEs, I've just shared the PowerPoint screen. Please follow that link, and the activity code is there. I'll leave that up for 15 minutes. Thank you, everyone. And thank you, Professor Hill.
Thank you.
Yeah. I was like, no.